Welcome to Law, Life, and Liberty with Anthony Puopolo.
Welcome to Law, Life, and Liberty with Anthony Puopolo. Anthony, a Massachusetts attorney who helps families navigate divorce, custody disputes, and criminal charges that often overlap. With offices in Lowell and North Andover, he's represented clients across Middlesex, Essex, and Suffolk counties in both family and criminal courts. I'm Lisa Mosby, and today we're talking about how property gets divided in Massachusetts divorce, from the family home to retirement accounts and everything in between. Welcome, Anthony.
Thanks, Lisa. Nice to see you again.
Thank you. When people first come to you about divorce, what are their biggest worries about who keeps what?
I think a lot of people want to make sure that they're going to still be able to retire. They've probably planned for retirement with the assumption that they were going to have a significant other who they're going to be depending on both of their retirement assets, that they're not going to have to pay for two separate homes. So the number one question is usually, how am I going to make sure that I can still retire and live comfortably?
Sure. And how does Massachusetts law generally approach property division? What does equitable distribution mean in real life?
So Massachusetts, as you mentioned, is an equitable division state, not equal. We generally look at what's fair. So, and that takes into account a variety of things. Because if we said it was equal, then that wouldn't be fair to people who there's a concept in Massachusetts called a super contributor, and the case on point in there is there was a person who not only contributed the bulk of the money to the marital estate, but also was doing all of the child rearing. The other party in that particular case spent a lot of time on social events. So if we said that's just an equal, then that disproportionately disfavors the person who over contributed. There is still a general presumption that you're going to land somewhere in the ballpark of a 50-50 split. But it gives the judges in Massachusetts a little bit more leeway to take into account the totality of the circumstances of the party's life and what would be fair, taking into account their earning capacity, their education level, the history during the marriage, and their future earning capacity.
Anthony, when one spouse owned the house before the marriage, how does that affect whether it's treated as marital property?
That's a good question. It really depends on a variety of factors. Are we talking about a divorce where there's no children? Are we talking about a divorce where there are children? What's the length of the marriage? So let's say hypothetically, let's start with the scenario where we're in a relatively short-term marriage with no children. In a scenario like that, the court's goal is going to be to put the parties back in the same position as they would have been had the marriage never happened, at least financially. So in that case, the party who didn't own the home prior to the marriage may likely be entitled to some amount of the equity gained during the course of the marriage, but the party who acquired the home prior to the marriage is likely going to get the lion's share of the equity. Now, if we talk about even a short-term marriage where children become involved, you've moved into this house as a married couple, you've chosen to have children in that house, you raise your children in that house. It becomes what we call woven into the fabric of your marriage. And it really is a critical part of your marriage, and the courts will view it as such. So at that point, you're probably going to want to talk to your lawyer, try to get an appraisal for the property prior to the date or the date of the marriage. And you can certainly argue to the judge that you should be entitled to the equity, at least for what you contributed to it prior to the marriage. But realistically, the equity during the marriage, particularly in a scenario where this was your marital home where you raised your children, that's going to be subject to equitable division.
And the other big asset that families generally have to deal with are those retirement accounts, like a 401k. How are they valued and divided? And what's the role of a QDRO in that process?
So that's an excellent question. In terms of a QDRO, that's called a Qualified Domestic Relations Order. And that's an order from the family court that requires a retirement account, which is subject to federal law, to divide the asset between the separating spouses. How it's valued it can vary depending on what the valuation date is that the parties agree upon. Now, if you are hopefully settling your divorce before trial, your lawyers are going to negotiate what the valuation date for the asset may be. You may mutually agree that it's the date that you separated. If one party moved out of the home and you mutually agree that's the date you're going to use, then you can do that. There's a lot of more flexibility when parties can settle than if we say hypothetically this goes to trial. If you go to trial, it's likely that the court will select the actual date of divorce, which can wind up leading a lot more of the money, the increase in value, to be subject to division. So there's a definite motivating factor there to try to encourage people to settle, because you get more of the control over how that asset is going to be divided. I tell clients all the time, we can use asset division as a negotiation tactic. Maybe you want the house, so you'll waive your rights to the retirement account, and in order to kind of have that give and take. So as far as valuation is concerned, typically what happens is we hire a company that specializes. So in Massachusetts, the one I use, one that really just does nothing else other than QDROs. They will value the accounts. They'll take into account the growth since the date that we select. You're going to want to take a look at what it was worth. If you have a retirement account that you came into the marriage with, you're going to want to know what it was worth when you came into the marriage, because the period of the marriage, from the date of marriage until the date that you select as the separation for the purposes of the QDRO, is what we call the coverture period. That's the period that is subject to division. If you can document that there's monies that were yours that you came into the into the marriage with, then you're going to have a strong argument that you should be able to retain that portion of the account.
So then, do the courts treat debt the same way they treat assets? For example, what happens when a joint mortgage or credit card balance?
So credit card balances are generally considered marital debts, but you can definitely make strong arguments that it should be attributable to one party versus the other. I've had divorces where I had one scenario where the person was spending $10,000 or $15,000 on shopping and social events, and those were definitely, they didn't contribute to the marital estate. So you're going to want, as part of what we call the discovery phase, which is the phase where your lawyer is going to send requests to the other side for documents, for bank records, credit card statements, you're going to want to talk to your lawyer. Let's say your spouse makes a habit of going to the golf course every single week, or goes to the spa every single week. You're going to want to document, to tell your lawyer that that's a spending habit, because those things didn't contribute to the overall marital estate, and you can make the argument that that person should be solely responsible for those debts. So it's not as clear cut down the line when you're dealing especially with credit card debt. Mortgage debt is generally going to be an equal debt, particularly if it is the mortgage on the marital estate. Now, if you've got a mortgage on, say, a rental property or an investment that you're keeping, then that's going to be your debt. So it really depends on what the mortgage is on. But if the mortgage is on your marital home, you can expect that it's likely going to be an equal debt.
And what about situations where one spouse moved out but is still paying part of that mortgage? Does that change how the equity gets divided later?
No, so you'll still be entitled to make the claim that you were entitled to the monies that, if you've moved out and you're still paying the bills, you will be entitled to a credit for the monies that you put in to maintain that home. It's often encouraged. There are rules that allow the family court to award use of the marital home to one versus the other, and particularly if you mutually agree. If you've moved out, your likely best bet is to ask your lawyer to file a motion for sole use and occupancy, so that it's just clear, look, I'm not there anymore. This person is living there. They should pay all of the bills. And then that kind of cleans up that messy piece, and it frees up some money for you to actually be able to pay for your new living situation.
And then when we add business interests or investments, I'm sure that complicates things. And what do you usually recommend clients do to get a clear valuation for those?
Businesses can be very difficult, especially when you're dealing with self-employed persons, um, particularly persons that may not keep the best records. I have a divorce right now where I sent records requests and the person just didn't keep good books, and it's very difficult at that point to get a clear idea, because tax returns don't always give you the clear idea of it'll tell you what the business has done maybe in the past few years, but it doesn't really tell you what the business could do in the next 15 years. So you really do want to have your lawyer hire a qualified appraiser who can go in, who can review the business to the extent that the records are there to be reviewed, and actually try to give you a proper valuation, especially because you want to do that, especially if you're going to be going to trial. Because if you mutually agree what the business is worth, then you don't have to have experts. But if there's a dispute as to what this business is worth, if my client says it's a $2 million a year business and they say it's 500,000 and they will not settle on that piece, it's going to have to go to trial. And as much as I would love to say I'm an expert on that, the judge is not going to consider me an expert. They're going to say, you need to hire someone who this is what they do. And I want to hear from that person as to what they say this business is worth. So it is important, if there is a business interest, especially, to do that right away. Now, in terms of investments, if you mean things like rental properties or things like that, again, a qualified appraiser looking back on, historic rent rolls, leases, things like that, those are really important. Investments themselves, if you mean like stock investments, those are just going to be subject to division, simply just as simple as most other financial assets. Again, subject to making arguments that you came into it. Let's say you were given, say, 10,000 shares of Microsoft 50 years ago when it was worth $10 a share, and you've had that your whole life, you never sold it, it never really became part of the marriage, you'll be able to really make an argument there that it's yours. But if you're talking about investments in terms of real property or um, other types of monetary investments that are not your standard stocks and bonds, you're going to want to talk to your lawyer about getting a proper appraisal done so you can make the argument as to the most appropriate division of that asset for you.
And for couples trying to settle rather than fight it out in court, what are some practical ways to reach a fair property agreement?
So I think it's important to get a good mediator. Um, as as a lawyer, my job is to fight as hard as I can, reasonably and ethically, for my client. That is also the role of the lawyer on the other side. And sometimes that does not inherently lend itself to lawyers being able to come up with reasonable agreements, especially if you have clients with strong feelings. So having a good mediator helps, because my job is also to set appropriate expectations for my clients and to try to help them understand what they can reasonably expect. But sometimes that's difficult because I'm too close, because I'm their lawyer. So having a good mediator gives a disinterested third perspective to both of the parties to say, look, I'm neither of your lawyer. I have no skin in this game. But most of them have been doing that. I have a great mediator. She's a retired judge. She was on the bench for 27 years. It's fantastic to have her in my mediations because she can tell my clients, I did this for nearly 3 decades, and I can tell you that I would have done X, Y, or Z if your case were before me while I was on the bench. And I think that can be really helpful in helping clients move towards a settlement, and also reminding him or her, that, especially if there's children, someday your children may want to go to college, and you don't want to give your children's college fund to your lawyer.
And I know you depend on the mediator for this, but are there times when you need to actually shift their perspective, their attitude, when they're using terms like winning the house or winning the money? How do you help them refocus on what actually matters long term and getting on the other side of this?
That's a great question. And again, part of what I do is to try to set those expectations. And when a client starts getting into, I need to win, it's really important to refocus them on the cost benefit analysis. Lawyers are not cheap. You are going to spend, you're not, let's say there's no children involved. You might want to retire someday. You don't want to spend your retirement fund fighting over a house that may not, that at the end of the day you might I had a client who spent the entire amount of equity they had in their house just to fight their other significant other over it. So it is really important to try to help them remember what the cost will ultimately be, and say, you want to move on with your life, they want to move on with their life. It's not about winning, it's just about what's best for you for the remainder of your life, including your retirement, including your children's college future.
Thank you, Anthony. I appreciate all the information today.
Thank you, Lisa.
That's it for today's episode of Law, Life, and Liberty with Anthony Puopolo. To learn more about Anthony and his work across Massachusetts family and criminal courts, visit agplawoffices.com. Thanks for listening, and don't forget to like, subscribe, and share this show with somebody who might need it today.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.